What's go, YouTube? American Rock said it again. Uh, what's up? What's going on? What's new? Uh, Special shout out to my subscribers, to the viewers, um, to the West Indians, the Indians, the original Americans. You know what I'm saying? By blood, ear to the Americas. Shout out to you all, you know what I'm saying? Wild Indians, you know what I'm saying? People who want to be free. What's good? In this presentation, I'll be discussing letters Rogatory. I've used one before in a situation. They were very impressed with it, but they were very impressed. So let me see now. So for Indians, speaking for Indians, you know, if you are in a situation as you haven't caused harm to anyone, as I haven't damaged people's property, you know, as long as you haven't broken the ecclesiastic code, the laws, the 10 commandments, you know what I'm saying? If it's a commercial matter, meaning commercial crime, as in colorable offenses, and there's not a contract, or they're forcing a contract upon you, or they assume or they presume that you were aware of the terms and the conditions of the contract that wasn't disclosed to you. Well, this should be an effective way of, you know, remedying whatever situations you may be in. If you wanna like a sample of what I've created, a letters Rogatory, because since what it really is, it's since these courts are foreign to you in any ways, because they're all foreign to you, because they're foreign jurisdictions set up on the land, because you're under military occupation. Unfortunately, you're under occupation by the military, colonial military, crown military, Vatican military. You're under occupation. This is how you gotta communicate, right? Through this letters Rogatory, because since they have no jurisdiction because of they're foreign to you, you need not to be in their courts. As the body, you need not to step in their courts, those kangaroo courts. All you gotta do is, because they're inviting you, and you could always refuse the invitation, okay? But you could communicate in honor, you know what I'm saying? In a honorable manner, non-belligerent, but honorably. So this is one of the methods you could use, okay? All right, so let's get to it. Letters Rogatory are the customary method of obtaining assistance from abroad in the absence of a treaty or executive agreement. Okay, so for all the non-politically affiliated Indians that didn't sign a treaty, and you're having issues to seek remedy in these courts, this is a perfect tool to use for you, okay? For all the Indians that didn't sign any of these treaties, break deals with these foreign people, and that honors nothing. You know what I'm saying? This is your way or method of making that agreement, okay? Or calling out the bullshit, okay? A letter Rogatory is a request from a judge in the United States to the judiciary of the foreign country, right? So you are the judge of your court, okay? The court is just the four corners of the paper, okay? That's your court, and you are the judge on that document, okay? Whatever you present is a motion to in your court, right? Because remember, you're in admiralty jurisdiction, so you need to have your court when dealing with these admiralty issues. Your court must be on the land, okay? stationary, not moving. Stay on the land. Don't go off in the waters and get lost. Okay. So right here it says United States to the judiciary of a foreign country. So basically, if you replace where you see United States with your court, meaning the United States itself, which is foreign to you as you and the origin here of this land, right? United States to the judiciary of a foreign country, requesting the performance of an act, which, if done without the sanction of the foreign court, would constitute a violation of that country's sovereignty. All right. So, within your court, within your tribal court, within your clan court, right? This is why you have to establish your house or your clan for the record, or put notice, give notice out that you have established your house using your own seal. You know what I'm saying? Your own marks. You know what I'm saying? Could be whatever mark you choose. Doesn't necessarily have to be a seal per se, but something, an impression, right? Something, of that, nature. Prosecutors should assume that the process will take a year or more. Letters rogatory are customarily transmitted via the diplomatic channel. So when you're doing these letters, you're actually approaching it from a diplomatic standpoint. All right, a time-consuming means of transmission. The time involved may be shortened by transmitting a copy of the request through Interpol or through some other more direct route. But even in urgent cases, the request may take over a month to execute. Okay? So the letters rogatory that I worked on, modified a little bit. It is for pretty much any case. Okay? It could work, and I suggest when you're using it, if you do choose to use it, right? If you want a copy of it, I could, you could send an email, and I'll just, share it with you guys. If you want to donate, you could donate, you know what I'm saying? But, as I said, I'm not for profit, not for gain. I just share information. But if you want to donate in order to help with, the office, our office, then you could do so. Okay, feel free to do so. Okay. The form of a letter rogatory depends on the country to which it is addressed, and the assistance sought. Some countries have statutory guidelines for granting assistance. Assistant United States Attorney should seek specific guidance from the Office of International Affairs, OIA, before drafting a letter rogatory. Letters rogatory generally include background, who is investigating, whom and for what charge, the facts, enough information about the case for the foreign judge to conclude that a crime has been committed and to see the relevance of the evidence that is being sought. Assistance requested be specific but include an elastic clause to allow subsequent expansion of the request without filing an additional letter rogatory. The text of the statutes alleged to have been violated. So when they're using that, you're transmitting utility, which is your ens legis, to summons that name, and they're trying to get you, the body, to appear by using that name through deceptive means. That's your estate. Okay, that's not you per se as a man or the woman. That's your estate. So when you're addressing these matters, you're addressing it from a third party, from a third person kind of, on the behalf of, okay? And you send this through the mail, certified or registered mail, restricted delivery to the judge, okay? Send these along with the W-9, okay? If you have a fictitious name, certificate, and pretty much that's it. You know what I'm saying? W-9, fictitious name certificate, and the letters rogatory. because you want to know who you're doing business with, or who wants to conduct business with you, and also your fee schedule. You should send your fee schedule. Okay. The text of the statutes alleged to have been violated and promise of reciprocity. Letters rogatory must be signed by a judge and normally authenticated by an apostille. Okay? So that's a method you could use as well. But you could authenticate your own documents, because since you have your own seal, that's a form of authentication, okay? But if you want to go ahead and get it apostilled with the Secretary of State, that would be a good idea. All right, because if you have your seal on it plus you get it apostilled, that'll be perfect. You know what I'm saying? Because it's a foreign jurisdiction. All right, and they know they could see the document, and they would have to honor it. Okay. To use an apostille, the chain certification is cumbersome process involving authenticating by the Department of Justice. The ascertain which method to use, because authentication requirements change frequently. Okay. Second, prepare a draft, right, and send it to OIA for clearance. Third, secure a judge's signature, because you are the judge. Okay. You are the judge on your documents. In your court, you are the judge. You're the chief justice in your tribal court. Okay, you call the shots. You authenticate. Okay, under your seal, under your pen. Okay, under your deed, under your seal. All right. Third, secure a judge's signature. Submit the clear final to the district court in 2 originals under cover of an application for issuance of letters rogatory and a memorandum in support, models of which have been obtained from OIA. One signed original letter rogatory remains with the court. Okay. Fourth, authenticate as directed by OIA unless OIA has instructed you differently. But this is for their procedures, right? For them, for the United States trustees. Okay. Fifth, make arrangement of translation of the letter rogatory, not the application or supporting memorandum, and send a duplicate original with a translation of OIA, which will transmit it to the Department of State, the American Embassy in the country concerned, or directly to appropriate ministry or authority in the country concerned. Okay, so since you are foreign to these courts, because you're an Indian, you're tribal, right? You maintain you maintain your cultural connection to your tribe, right? You haven't severed your cultural ties from your tribal community. You still maintain the customs, right? You have the power to do all of this, right? That's from a foreign court, because your tribal court is foreign to this United States, okay? Which will transmit it to the Department of State, American Embassy in the country concerned, or directly appropriate ministry or authority in the country concerned. If OIA transmits the letter rogatory with translation via the diplomatic channel, the embassy will send it to the foreign ministry under cover of the diplomatic note. The foreign ministry will usually refer it to the Ministry of Justice, and the Ministry of Justice will usually forward it to the proper judicial authority, where it will be executed. Normally, the evidence once obtained is returned through the same channel by which the request was transmitted. So, in this letter rogatory, since everything is commercial, since all these courts are bank, this letter rogatory will assign the judge as a fiduciary trustee, right? So he could settle the case for closure and balance the books, okay? Because it's all banking. That's all it is. It's just credits on account, right? It's all about banking. Zero the books, all right? There's a charge. The one who brings the charge must have remedy, all right? So this is another breakdown of letters rogatory. 22 CFR section 9254. Letters rogatory defined. In its broader sense, in international practice, the term letters rogatory denotes a formal request from a court in which an action is pending to a foreign court to perform some judicial act. Examples are requests for taking of evidence